To the public hearing, we have a public hearing this evening. Item number 4, amendments to the Cannabis Business Ordinance, AMC 9-5.3845 regarding development agreements, delivery, and separation requirements. Turn it over to City Manager Ron Bernal.
Thank you, Mayor Wright and members of the City Council. This item is related to the Cannabis Ordinance. There's been a couple of modifications made, the largest one being the addition of a development agreement requirement to the ordinance in order that with the city not having a cannabis tax in place currently, we could assure the residents and the City Council that there is a positive benefit being derived from cannabis business coming into the City of Antioch. So our Community Development Director, Forrest Ebbs, will give you a more thorough presentation on this item and answer any questions.
Thank you. So this evening I'm presenting to you an ordinance that would amend our existing cannabis business ordinance, which is located in our zoning ordinance. The history for those in the audience is beginning November 16th with the passage of Proposition 64, the state of California started to look at recreational cannabis as a business in California and as something that would be permitted and deferred to local cities to come up with their own rules, and that's what we did. So we have an effective permitting mechanism, and we have about 6 applications in right now. We're expecting more. We're in communications with some other folks too, so it's had the effect of opening those doors. When we drafted our ordinance, we intentionally put in an additional finding that required the city to determine that with each application there is a net benefit to the city. And that's unique because with most use permits, the finding is simply that you will do no harm. That's the standard we try to achieve. This is a step above that in saying you shall provide a net benefit. And so in looking at these and talking with some applicants and looking at what other cities do, we came to the conclusion that the development agreement is the best tool to accomplish this. Development agreement is a contract. It's regulated by state law. You adopt it by ordinance. But at the end of the day, it's a contract between 2 parties, the City of Antioch and the developer. That tool is used for a whole variety of purposes. Most of our larger residential subdivisions have a development agreement. Typically, a subdivision under state law is good for 2 years, but a development agreement can extend that for a large project. So this is just one possible use for a development agreement, but it's a very common tool and sort of a very generic tool. So what you have before you is an amendment to our zoning ordinance that would require that parties enter into a development agreement for each use permit for a cannabis business. The exact language is contained in the attached ordinance on page A3 of your packet. And it states simply, prior to operating in the city and as a condition of issuance of a use permit, the operator of each cannabis business shall enter into a development agreement pursuant to Government Code Section 65864, known as the Development Agreement Statute. And it goes on to give a little bit more detail. So every applicant would be compelled to enter into a development agreement. Now what that development agreement requires and states will be unique to each application under the law. We cannot adopt a standard because each of these is a contract. It would be disingenuous to that purpose. So what we've provided to you, and for those in the audience, these are at the back table there, we drafted a template. And what you'll find is that there are some helpful definitions. This is a template for a development agreement. This is what you will likely see coming down the pike in the future. What will be unique are some of the provisions in here. And what we've recommended what we've presented to you is just one example of what you might see in terms of revenue sources. That came up earlier tonight. Our proposal would have a sliding scale for revenue based off of square footage and also off of percentage of gross receipts. The numbers that are in there are a basis for a conversation It's something that we'll be talking to our applicants with. And when you see an application on the 23rd, you'll likely see a development agreement that looks a lot like this, but we'll just have to talk about the numbers of them and make sure that they're on board with them. We think they're fair. We think they're consistent with what they're competitive with what you'll see in neighboring cities. We did look to others. And I think they'll put us in a position to be very competitive. They're slightly below market right now, slightly, which means, Antioch will become an attraction for that. So that is the goal of the council. That is a way to achieve that. I mentioned earlier that the city of Oakland recently changed their percentage from 10 down to 5. They were getting slammed by people saying it's just too expensive. So those are the numbers that are in that draft development agreement. I'm not asking the council to adopt the draft template. I'm just giving you that for informational purposes. And if you have any questions about how this would work, it's something you can look to. I can take questions anytime, by the way, if there's something.
This is a public hearing, so are you done with your presentation? So I can open up the public hearing?
I'll wrap it up right here because there's a couple other little minor changes relating to cannabis delivery. I think it's pretty self-explanatory. We just wanted to separate delivery from retail in anticipation of standalone delivery operations that will operate like a distributor, not like a store. And the Planning Commission asked that we include on the list of sensitive uses childcare centers and require that cannabis businesses be located no closer than 600 feet from them. Childcare centers are defined by our zoning ordinance. These are not the in-home daycare centers. These are the larger ones like the kinder cares, the standalone, larger facilities. They're defined. So I have included that too. So if right now we don't have a conflict, we don't have any childcare centers within 600 feet of the cannabis business zone, but if we ever did, it would come into effect at that point. So I'll conclude there and take any questions you may have.
Very good. This is a public hearing, so I will open up the public hearing portion of this. Are there any requests to speak? Public gets 5 minutes. Charles Wesley.
Good evening. I'm Chuck Wesley. I'm one of the managing members of Contra Costa Farms, and you're aware that we're developing a large parcel on Wilbur Ave. I have one concern about the child care center addition, because those can spring up where a park or a school, things like that, those have some permanency. Those are institutions, if you will. So my concern is this. We've already spent $45,000 just to get to the deemed complete application, which is where we're at now. So now this goes into a 3-month sequence study, right? What happens if 30 days from now, KinderCare or whoever opens up a child daycare center within 600 feet of our parcel?
I can actually answer that.
Yeah.
Under law, your application is vested in the sense as soon as it's deemed complete, only the rules of that day will apply to your application.
Thank you.
Are there any other requests to speak?
None received.
Seeing none, the public hearing portion of this is closed. This item is now before council. Councilmember Wilson.
Yes, so quick question, just a clarifying question. So we have the annual payment, which is the $1 for the first year and so on, et cetera. And then we have the quarterly payments on the gross receipts starting at 2%, then 3%, and then 4%. Can you explain, because it sounds like the tax is already built in there, but it really isn't, if I'm understanding this correctly?
So I want to be very clear, this is not a tax.
Okay.
The fee, the agreed to compensation that would be in here, community benefit fee, I think we're referring. Mm-hmm. Yeah, it would be, this is a general framework. So
okay.
This would be all of the benefit the city.
Benefits, okay,
Yeah.
I just needed a clarification on that. And then you just said something about delivery and how, I guess the Planning Commission really asked you how we were going to charge these fees to delivery.
No, staff actually identified the conflict because delivery was under the umbrella of retail, and retail has a 600-foot separation. We had an operator who came in and says, I don't want to do retail, I just want to do delivery. And because we had the two merged,
Okay.
it created a conflict because they were subject to the separation.
And I'm assuming this person that you're referring to did have, although wasn't selling from a location, they were located in Antioch.
Yeah.
Just weren't selling, they were just doing straight delivery.
That was their intent. So it brought to our attention, oh, there's a conflict here, and that was not our intent, was not to create that. So we're separating them for that case and for anything else that comes down in the future. So delivery would be subject to the same conditional use permit and everything else, and we would look at the benefit structure based off what they're
Other
doing.
delivery would also fall into this?
Yes,
Okay.
everything falls into that, yes.
All right, thank you.
Councilmember Overchalk.
I have a couple. You know, when we started this process, we talked about a tax, a cannabis tax. So I don't know how we went from a cannabis tax to a DA.
Yeah, I mean, I can tell you that there was not a tax on the ballot last year, and the next opportunity would be next year. And
Prop 218, it has to be on the ballot.
yeah, so it would require, a high majority. And this is before us right now, so this is the immediate tool. So rather than wait, now at the same time, if a tax were to come about in a year or in 3 years, all of these could be negotiated. Our intent, I don't think, would be to have people doing both, but maybe it would be the intent. But the
No,
reason why we
there's
do this
actually
now
a-
is this is immediate.
There's actually a provision in there, so if a tax comes that's greater than what you've negotiated in the development agreement, then that tax will supplant the development agreement.
Thank you. Okay, so that answers that one. We do have, I had asked about a month or so ago to bring it back on the 600 feet because we have some youth activity areas, youth sports complex out on Wilbur Avenue, and we also have one on 10th Street going to Pittsburgh, and I believe there's one more, and it's not coming to my mind. They should be the same, 600. Even if it's not a city park, it's where our youth are at, and I believe that we need to have that buffer. But I'm going to take that back and say that it should be, we have a gambling ordinance in town, and it's 1,000 feet. So I think we should be aligning this to something that we already have. And the reason that the 1,000 feet was put in there for the gambling, again, it went to the youth. The other thing is that there's some other things on the gambling ordinance, and one of them is churches, and I wrote down churches also. So I think that because the youth go to the churches, as you just heard from the ad hoc committee, they're there a lot. Catholic churches have CYO basketball, that was brought up. There's a lot of youth activities at churches, so I'm asking that we consider adding the churches and just aligning this ordinance to the gambling one. That's another one. Did you want to add? No?
No, I would just say that if you're going to make changes to to this particular ordinance that's in front of you, then you would have to go through doing a first reading again. But an option, if you decide that you want to go with the ordinance that's here today, but still accept the recommendations that have been made, you could always make those changes at a later point in time. So there's, two options depending on how eager you are to set in motion the chain of events that'll actually occur, because you have to, get through this ordinance and then the development agreement and the cannabis business that's coming will require another ordinance. So there's a sequence of events that'll happen that go several months into the future.
Yeah, but then, as this gentleman just stated, if he's doing his due diligence on it and he's thinking it's 600 feet, and his 600 feet on Wilbur Avenue doesn't encompass that youth sports complex, and then we come back and say it, that's not going to work.
That's right.
So that's not going to work. I apologize. Thank you, though. The other thing is the gross receipts. I was looking at 2.12 and talking about gross receipts. How do we verify gross receipts when it's an all-cash business?
That's a good question. I'm not the expert in verifying that, and just like with business licenses, I know there's a state, and I can't give you a good answer to that.
Okay, I have...
And I'd have to work with our attorney and our finance director on the protocol for that.
Okay.
It's just not my area of expertise today.
Okay. I mean, it is kind of concerning because we won't know on a cash basis. I mean, I know business owners that when they have cash in their hand, they don't have to claim it. So it's a little different. It's on an all-cash basis.
Sure.
Sorry, I have to read all my notes. I apologize. Okay, so another thing I learned when I went to, I spent the day viewing different cannabis businesses, and in Oakland and Berkeley, I believe, they had incubators designated in areas of the cannabis business, and that was a way that they were giving back to the community. I know there's a community benefit fund in here, or fee, but the cannabis owners loved that idea, and they gave them like a small portion. It doesn't have to be like 1,000 square feet, but it was something for an incubator business to come into. And in Oakland, it had to be related to cannabis business. I don't think it has to be related, but when we're looking for economic development, we want small businesses to occur here in the town, incubator spots for small businesses to see if they're actually going to work. They do have that in their guidelines with the cannabis business, so we could pull something from Oakland to see what it says. That wouldn't stop us from doing, moving forward, but the other ones would, but we could get that information from Oakland to see how they put it in there. And they say it's a very, very valuable tool. And they've gotten a lot of good businesses started within these incubator businesses. And I know that the mayor had talked about this at one point for some of these small businesses to have a spot, and this would be the perfect spot. Just my thoughts.
Councilmember Ogurchuk. Oh, I'm sorry, Councilmember Thorpe.
Twice. And he doesn't have any hair.
So, this is just a framework. So this incubator would be something, if we expressly wanted it, we could negotiate it with the applicant.
Sure.
Or anything for that matter.
Yes.
Okay. So I'm with you in terms of looking at the policy. Not necessarily now. I thought we gave direction, so you have that. We have that express understanding where staff comes back within 6 months. So I'm assuming it's part of your timeline. So I'm personally just interested in seeing this framework that's not set in stone. This framework that we just deal with that and deal with the other stuff at a later time.
Mayor Pro Tem Motz.
I just want to clarify again for us, so, this template is something that you took from what other cities are doing in regards to?
Actually, Derek Cole on contract developed this for us. But it is a combination of kind of the best practices out there. That's where he went to do it.
Okay. Well, then I would be in agreement with Councilmember Thorpe that we go forward with this, and then if there's additions or takeaways later, that we do that at a later time.
I'm sorry, I didn't mean to be dismissive. I just didn't want to take credit for this very lengthy legal document. I think that's illegal on my part. Thank you.
No, I just appreciate the fact that you did the due diligence of going and seeing what is working and happening in other cities that have already ventured into cannabis. Thank you.
Councilmember Thorpe.
And that was just to reiterate your point on, and I wanted to specifically, and I know the mayor has expressed the same, that we wanted to look at the map as well. We wanted to deal with the 600 feet thing in different variations, and that I think the 600 feet, when we initially thought about it, we were thinking about dispensaries. But as I've learned more, I can't speak for the mayor on this, but as I've learned more, the dispensary is a storefront, kind of like the gambling and whatnot, or a liquor store, and so we want that buffer. But for other things that I'm not necessarily sure that 600 foot requirement makes any sense. We should have various should be associated with the type of cannabis firm, not necessarily just because it's a cannabis firm.
So perhaps we can agendize a general discussion on the whole cannabis ordinance, the whole process at a forthcoming meeting.
Yes, and just so so that the public understands, we do not have a sales tax, and a sales tax would have to be passed by the people. We'd have to go out to the ballot. The next time that could potentially happen would be 2020, right? Is that correct? November 2020?
We don't have a cannabis-specific sales tax. These folks would still have to pay the general sales tax.
but a cannabis-specific one. And so this is a,
Yeah, the next available election would actually be
May
the
of this
March primary in 2020.
so, this is a fee agreement that you would be making with potential users, and they would be agreeing to basically pay these fees as you go in. What my question is, it sounds like the 2, 3, 4 is then negotiable as you go through that process. Is that?
That's correct. Yeah, there may be more creative ideas, but part of our job will be to make sure that we bring you something that's equitable and consistent with market practices.
So the other question I had, I've had some people call me and question the gross square footage versus a canopy concept as far as, but it sounds like that also would be negotiable as they go through the contract with you.
Yeah, and I think the canopy issue is resolved in this current draft right now, because I did notice that it's a canopy and it refers to a state definition of canopy, so it's very standardized.
Okay. All right, I'm ready to move forward with this. Any other comments or questions? If not, do I have a motion? Motion by Councilmember Thorpe.
I'll second.
Oh, please read it.
Or Arnie will get mad at me. Oh, here it is. I'd like to make a motion that an ordinance of the City Council of the City of Antioch amending Article 3845 of Chapter 5 of the Title 9 of the Antioch Municipal Code include the requirement of a development agreement amending definitions related to cannabis retail, cannabis delivery, and requiring a 600-foot separation from child care centers.
I'll second.
We have a motion by Councilmember Thorpe, a second by Mayor Pro Tem Motts. Please cast your votes. Oh, discussion.
Okay, I again have concerns regarding the distance of separation. So if somebody, such as the gentleman that just got up and spoke on behalf of Wilbur Avenue, and we come back and say it's 1,000 feet, and he understood it to be 600, what's going to happen to his application?
So
Wait a minute, hold on there, Buckaroo.
So that particular application would not be affected by any
So he's
change.
vested, so he gets to do what he wants to do?
Yes.
Okay, so
We can't change the rules at this point on him.
there's a lot of children that play in that sports complex out there, and the same thing with the one on 10th Street. And I don't know that 1,000 feet, and I don't know what the businesses are in either one of them. Maybe you gentlemen do. I don't know. So without knowing what's going in, I don't think that we should be putting those children at risk until we understand fully what's going on.
You're responding to Mr. McClellan's concern about the. Okay, so you're talking about the one on Wilbur.
Yes.
So let's just say we came back and changed 1,000 feet.
Well,
No.
I just want to be careful that tonight
No,
we've
no,
agendized
wait.
very specific changes, and I would like to come back and have a comprehensive discussion, but, I think changing things outside of the three basic issues that were brought forward, I would maybe look to the city attorney. I'd be concerned
Okay.
about
No,
expanding the
I
scope
was
of
going
this
to point out
change.
that the application that you're
Right.
talking about is his application. It's beyond 1,000 feet. It's not going to. It is.
I can tell you right now, it's my understanding it's 400 feet.
And that application will be before you on the 23rd. No, not that one, but other applications will be. So beginning on the 23rd, you'll see real applications, and we can go from there. And again, I'm happy to come back with a more comprehensive discussion.
Any other discussion before we vote?
I thought Mr. Ebbs asked our city attorney a question.
Can you repeat the clarity about, would it be appropriate this evening to discuss issues beyond the three that were agendized?
Oh, no, so if you want to make the changes that Councilmember Ogertalk recommended in terms of, expanding the distance and doing those, including churches and making those other changes, then that kind of change to an ordinance would mean that you would have to come back and do another first reading. You wouldn't approve it today. You would make the changes to the ordinance, come back and do another first reading, or, like I said before, you could approve this ordinance today, but then this is the set of rules that would apply, and then you could come back again and make those additional changes that she made. But if you want to collapse the process and do them all at one time, then you would want to bring this back with the changes that she's recommended, if that's the will of the council.
So I'll put that as the will, as a question. Is there a consensus to make those changes or hold off and discuss those changes, I guess is is there a consensus to hold off and discuss those changes at a future? Hold off the approval so that we can discuss changes with the types of business that it could be around and the distance. So the option before us is to approve what's before us here or to hold off and discuss those at a different meeting. So is there consensus to hold off is kind of what we're looking towards. If there's not consensus, then we can move to vote.
There's a no for me.
Are we holding Mr. Wesley up in his process?
Well, none of the applications would be held up by any action or no action tonight. What we're trying to do is get to an area of greater certainty with these applications. So we're cleaning things up, we're tightening things up. So as they move through, we have that. If someone came forward and was, really didn't want to have a development agreement, we didn't have this in our code, it would be very awkward because we'd be talking about the finding and how do you get there, and this offers a lot of clarity, certainty.
And so when you pass the ordinance, so you'll have the first reading, the second reading, and then 31 days after that, it becomes effective. And so if you decide that you want to take Councilwoman Ogerchalk's suggestions, which would be, I heard one which was increasing the distance from 600 to 1,000 feet to including churches and other recreation centers not owned by the city that are private. If you wanted to include all of those, then essentially we'd be pushing back the process, and so it would be another first reading, but with those changes. Then you, at the next regular council meeting, do the second and have the second reading with the approval. Then 31 days after that, it would take effect, and it would apply from there forward.
And just so you know, since we'd have to publish the public notice 10 days in advance, so it would be impossible to be at the meeting on April 23rd. You're talking about somewhere in May, and staff would still have to come back, to do it, and then we still have to make sure that by the time we get it, we do the 10-day notice.
Mayor Pro Tem Motz.
From what I've seen, and this is prior to my being on council, that this has been a very thoughtful process by this council and the city, and also from our previous city attorney, in making sure that, the overlay and the areas where this could be, were strategic, and that what I've seen even in the operations that are coming forward from us is that, and through the Planning Commission, that they are taking every precaution. The security involved in this is, I think, one that was asked for from the police department, and they are meeting that obligation. So, based on this very careful process that the city has been going through with this, I feel comfortable moving forward.
Councilmember Wilson.
Yeah, I can move forward with this because we don't, until we determine the measurements, which I'm only going to accept from your staff from doing the exact measurement, because I'm not going to sit here and assume tonight, 400 at 600 or whatever. I would want to move forward on this, on what you've presented today, so we can go through. I mean, it sounds like from what I'm hearing from the city attorney, if later down the road we want to make some changes, updates, that's still in the realm of possibility, correct?
Yes, you can make those changes, but then of course, they'll apply from there forward, right?
Yeah.
Okay.
Thank you. So yeah, I can go forward with this tonight.
And I'm going to point out one last thing too, is the council still has the ability with every application, it's nice to have a standard to rely on, but you have to make some very subjective findings too. So if there's something that's 601 feet away, that doesn't mean it's in the clear necessarily. So you do still look at these case by case, and you're not compelled to approve everything just because it meets a dimensional standard.
There is a majority to move forward today, so I will call for a vote. Please cast your votes.
There are 4 affirmative votes, 1 vote in negative. Councilmember